People's Platform.
Good evening and welcome to the People's Platform. It's essentially a man's world. The systems, processes, mindset, culture, society, religion, research, medicine, they're all curated and geared to the benefit of men. Gender intersects at each level of policymaking, and throughout history we've seen gender blind governments across the world. We've seen gender insensitivity in policymaking. Sometimes we also see gender exploitative practices and policies. A few months ago, President Ranil Wickremesinghe said it's imperative that women's rights go beyond mere rhetoric, as a result of which the Women's Empowerment Bill and the Gender Equality Bill were gazetted and placed before the order paper of Parliament. Since then, the Gender Equality Bill was challenged before the Supreme Court and was struck down. Where are we headed now? Let's find out. I'm so pleased to welcome to the studio two of my favorite guests, Professor Deepika Udugama, Professor of Law, University of Peradeniya, former chairperson of the Human Rights Commission of Sri Lanka. Good evening and welcome.
Good evening, Sonali.
I'd also like to welcome back to the show Dr. Gehan, Goonetilleke, Attorney at Law, Commissioner of the Human Rights Commission of Sri Lanka. Welcome.
Thank you for having me.
Professor Deepika Udugama, let's talk a bit about the present status with respect to these two bills. Recognizing gender is so important in policy making. We can't be gender blind.
Absolutely not. I mean, in many ways, these pieces of legislation, or at least if they were amalgamated, at least one piece of legislation, were really long overdue. It's because in Sri Lanka, women have gained so much over the years, on the one hand, in the fields of education and healthcare, but on the other hand, lag behind seriously in certain areas, such as in the labor force. For example, it's just about 35%. It's hard to believe. Whereas in universities, we have over 60% of women. If you look at the political representation, Parliament has the lowest percentage of women, and local government authorities, etc., when they were, operating, were really low until the quota was introduced. So this is absolutely essential that the serious issues that women face in society be taken note of, recognized, acknowledged at a policy level, at a legislative level, and be addressed. So we have in the Constitution a provision, Article 12(2), which says that no one shall be discriminated against on the basis of, amongst other grounds, sex. And that's it. And then there's another provision, Article 12(4), which says that the state can enact or adopt special measures for the advancement of women. Other than that, there's no other provision. No other provision. So many countries around the world have specific laws relating to the challenges facing women in order to correct them. Further, Sri Lanka has ratified the International Convention against the elimination of all forms of discrimination against women, the CEDAW Convention, and is bound by it. So Sri Lanka has to, under that convention and also under our constitution, ensure that in every field of human activity, political, economic, cultural, family, whatever the field, that women have equal opportunity. So we don't have that specific piece of legislation. And if I may just take another minute, Sonali, Women's Rights Bill was drafted at the turn of the millennium in Sri Lanka. I was very young then, many decades ago, and it was drafted by the National Committee on Women, which is attached to the Ministry of Women.
Okay.
And I remember serving on a committee chaired by Professor Savitri Gunasekara, then around 2002 or 2003, to review this bill, which was really good. It was solid. It had the constitutional framework referred to, the CEDAW framework referred to, and the establishment of a National Commission on Women. But over the decades, it got lost in the pipeline. It was considered by certain administrations and rejected on cultural grounds and various, according to their political vision for the country. So now it is there. It's a absolutely necessary piece of legislation, But now the confusion is that there is the Women's Empowerment Bill, and on the other hand there is the Gender Equality Bill. Now the Supreme Court last week struck down completely the Gender Equality Bill. So that's where we are. The other one, the Women's Empowerment Bill, as far as we know, now it was gazetted in March. It has been placed on, I think it has been placed on the order paper of Parliament in May. Yeah. So we have to see how things follow.
Gehan, this provision that Professor Deepika alluded to, Article 12(2) of the Constitution, which says no citizen shall be discriminated against on the grounds of race, religion, language, caste, sex, political opinion, place of birth, or any one of such grounds. So, we've seen how when we look at the jurisprudence of neighboring countries such as India, words like sex have been given an expansive interpretation to also encompass gender. Speak to us about the power of interpretation.
So that's a great question. So we have to first try and understand what Article 12, paragraph 2 attempts to do. It's actually setting out a prohibition. Right. It's saying that the state, essentially executive and administrative arms of the state, cannot discriminate on these grounds, right? Now, if a government was to bring a bill that expands on these grounds, it doesn't need to be inconsistent with the prohibition. The prohibition is about what you can't do. That doesn't mean that you can't, by virtue of a bill that is scrutinized by the public, that is scrutinized by the Supreme Court, expand the protections that are offered to citizens. Right. So these are two different things. So you have to understand a prohibition is not a prohibition on a prohibition, if you know what I mean. So you see there are many laws that expand on rights. And a fundamental rights chapter is by no means a prohibition on Parliament's ability to do that. So you will have, for example, the Right to Information Act, which is much more expansive than the right to information that is guaranteed by the Constitution. But no one will say that that's inconsistent with the Constitution.
Right.
So you have to understand that when you legislate legal rights, that doesn't necessarily mean that you're inconsistent with the prohibitions on certain grounds. And that list of prohibited grounds might be, exhaustive. That there are ways of interpreting it in a way that is, with a little bit more latitude. But let's assume that it's exhaustive. That's not a bar on Parliament to be creative and expand that. So I think the idea behind this bill was a salutary idea. It was an important measure to recognize that our current law had gaps. And I think it was a welcome idea. But I agree completely with Professor Udugama that there's a process that has to be followed to actually see this through. And I just wonder whether we had a practical, sensible process, a consultative, inclusive legislative process that ensured that this bill will see its passage. And I think there are some important lessons to learn from this failure.
Professor Udugama, do you think that the lawmaking process in Sri Lanka is chaotic?
At the moment it is chaotic, Sonali. Unfortunately, I have to say that. Because, the lawmaking process has to be very thoughtful. Because after all, the legislature the members of Parliament have been elected by the people, mainly for the legislative process. I mean, there are other functions too, but mainly for the legislative process. Now, that means the legislation that is enacted has to cater to the needs of society and even sometimes be very idealistic, from the perspective of the Constitution, our international law obligations and so on. So, from that point of view, they have to be carefully drafted. You have to take time. It doesn't mean infinite period of time, but a reasonable period of time, and you have to be consultative. As Gehan said, you have to consult the various communities, the groups that are going to be affected by it. You have to consult all types of experts. But that doesn't seem to be happening. Now, in recent months, what we have seen is sort of a race to I don't know where. Because we have been told since this administration took office in July of 2022, 70 plus pieces of legislation have been enacted. Now, what for? Because they are so, quickly drafted, we don't know who was drafting them, who's been consulted, and thanks to the active citizenry of our citizens on that score, almost every bill is being challenged before the Supreme Court. So, you have to look at the pressure on these institutions also. Each bill has to be gone through by the Attorney General's Department, and a certificate has to be issued to the Speaker. This bill is in accordance with the Constitution. So, the bills keep piling up. Now, what we have is a situation where the Attorney General gives a certificate saying these bills are constitutional. But then when citizens challenge these bills, the Attorney General comes and suggests various amendments to make it constitutional. So, there is a contradiction. So, the process is, in my opinion, absolutely distorted, absolutely distorted. The Supreme Court is not a standalone constitutional court. A constitutional court, its only function is to review bills. This Supreme Court has so many powers. Criminal appeals, civil appeals, fundamental rights cases, and then of course review of bills and constitutional matters. So when bills pile up like this, where's the space? Where's the time for considered views and opinions to be given? And the Supreme Court has to give its special determination on a bill within 3 weeks.
That's right.
So that is really rushing things. The legislative process, the success of it is not determined by the numbers or the pieces of legislation that you enact, but by the quality. And right now what is happening, even these pieces of legislation that, as Gehan said, are very needed and salutary, are not being drafted properly. I'm sorry, I have to say the gender equality bill, although it is on a very salutary topic, theme that is absolutely needed in society, I mean, it lacks conceptual coherence completely, So at one point it speaks of advancement of women, gender equality being for the advancement of women. In other provisions it's about advancement of women, men, and those with various other gender identities and so on. So there is no conceptual coherence. And I think when the bill was reviewed by the Supreme Court, and I mean with due respect to the court, I really think the assistance that the court needed to really unpack this bill, that wasn't there. So the intervenient petitioners, that civil society members, they came in late, so the court couldn't permit them to present their views, and the sharpness with which these concepts should have been dealt with was not there. And so the whole bill, the entire bill went under.
Yeah. Gehan, what are the lessons to be learned from this?
So I mentioned that this process needs to be consultative. So on the Human Rights Commission, there is a specific mandate where we can provide some recommendations and observations on draft legislation. And for that to happen, we need to get copies of the bill. Often what happens is we only see the bill when it's gazetted, and then we have to rush. That's what happened with the online safety bill, for example. We had to produce those recommendations in a matter of days, because once it's placed on the order paper, it starts getting a little complicated because there's another entire jurisdiction that has now taken cognizance of that bill. So we try not to, interfere with that process. So we had to rush. With a couple of days, we had to read the bill and produce observations. I must say this process was much better because the Presidential Secretariat sent certain early drafts of the bill to the Human Rights Commission. What is a little baffling is that the comments that were sent on that draft, I'm not sure were actually incorporated, because the version that was placed on the order paper appears to be a completely different version. I couldn't recognize the version that I got.
That can't happen, right?
So
Why is it happening?
Well, I suppose they're not bound to take the recommendations of the Human Rights Commission. I mean, these are just suggestions. But it does speak to a incoherence, and I agree with Professor Udugama that somewhere in this pipeline there is no real consistent actor that is pushing the thing through. And normally it should be the line ministry that does so.
Sure.
So I think there were definitely people that were really interested in getting this bill through. There were people that were really seeking consultation with the Human Rights Commission. You could see that they were good faith actors. But
Right.
they have to work with other institutions like the Attorney General's Department, like the Legal Draftsman's Department. And in that kind of milieu, you get a bill that was not really coherent and not consistent with some of the recommendations that had been made earlier. So I think the court picks up on this conceptual incoherence and comments on it. And there's a lesson to be learned there, that this country has enormous expertise. We actually sometimes rely on international experts when the domestic experts can actually give you enormous, valuable, rich feedback. I don't think we really make use of our local talent.
Right.
And then we complain about our talent, going overseas, right? So I think that's an important lesson, that we really need to trust civil society. We need to trust our scholars, our academics, and include them in processes on conceptually, complex issues. And you can see from the bill, you can see even from the determination, this was a conceptually complex issue. There's gender, there's gender equality, there's gender identity, there's the whole issue of sex. I mean, this required some, bright minds to be part of the process.
Right.
And I'm not saying that bright minds were not part of the process. I'm just saying that there's a lesson to be learned about ensuring that when the court, that quite rightly Professor mentioned that it's an inundated court, when the court receives a conceptually complex document, it also has recourse to all the expertise before it, right? So then then it's a rich process that you can ensure will ultimately produce a bill that is worth passing. And I'm not sure that that's what we got with this particular experience.
I'd also like to bring up the point of the Women's Empowerment Bill, which was also gazetted and placed before the Order Paper of Parliament. It seeks to establish a separate commission dedicated to women's upliftment and empowerment, also vested with the responsibility of formulating a national policy which will be entrusted to this commission. Professor Udugama, how do you view the salient points of this bill?
Yeah, that bill is much more, there's more clarity and there's order. I think it has also borrowed a lot from the original, the bill that was drafted and then evolved over the years. It basically points to specifically to the advancement of women, as you pointed out, Sonali, and says that this is the objective is exclusively to uplift to recognize the rights of women and to uplift the the condition of women, and there are various other objectives that are there. And one of it, as you very well rightly pointed out, is to draft a policy on women, the advancement of women. So that's absolutely important. Then in addition, then it points to the fact that the legal framework there is the constitution of the country and then international legal obligations of Sri Lanka, which means CEDAW.
Right.
And CEDAW is not a strange thing to any of these institutions because we ratified it way back in 1981. So if anybody says that this is a new thing that is thrust on the country, that is absolutely not correct. It's disingenuous because we have been dealing with these obligations under CEDAW. Then it goes on to point to the fact, establish a National Commission on Women. And the National Commission on Women is to be an independent commission that has the powers of investigating and inquiring into allegations of violations of women's rights by not only state authorities, by any party, because a lot of the violations or abuses take place by private entities. So if you look at the employment market, I mean, many women are employed not only by the public sector but by the private sector as well. So, and sexual harassment happens on an individual basis. So there is a lot of progress there. And then, like the Human Rights Commission, the National Commission on Women can make recommendations. And there's a novel provision here. If you are aggrieved by it, you can appeal to the Court of Appeal as well. Now, so overall, I think it is much better drafted. There is conceptual coherence, all of that. But there are some provisions that have been included that really compromise its independent character. And I think that those have to be dealt with. One is where the president can dismiss the chair of the commission. There are 7 members, 7 commissioners. They are to be appointed through the recommendation of the Constitutional Council, and it's on that basis that the president can appoint. But removal of the chair at any given point can be done by the president without consulting anybody, not even the Constitutional Council. This is very serious, very, very serious, because the president can do away with the chair, and the next chair that comes in is extremely conscious of the fact that there is this insecurity. The other is that there has to be a director, executive director of the commission who sort of runs the administrative and is in overall charge of the running of the institution, the commission. The president appoints the executive director, and the president can remove the executive director without any consultation. These are very dangerous provisions that compromise the independence, and these sort of practices can move on to other commissions also. So these things have to be nipped in the bud. There's another provision which says that of the 7 members, 2 have to be nominated by the Parliamentary Women's Caucus. Now, I have the greatest admiration for the caucus, and I will do anything to support the Parliamentary Women's Caucus. But this on principle is problematic, because independent commissions mean that no political authority or political representative or representatives must be involved in the nominating or the recommendation process. Right. This is done, I think, in good faith, but the consequences can be very serious. So I think it's important. Perhaps what could be said here is that the Women's Caucus in Parliament can nominate suitable members to the Constitutional Council for its consideration. So there are a few other points like that, but this is vastly better than the gender equality bill. I just want to provide a slight clarification here, because there may be viewers who are wondering what is this gender, what's sex, and so on. I think that's very important. Sex means, if somebody has been discriminated on the basis of sex, means somebody has been discriminated against on the basis of your physiological features, the biological features. But gender means the sociological, how society reads your physiological features. So women's reproductive role, for example, society reads it in a particular way and says that, you are the one who gives birth, etc. So your role in society is this. You have to be confined to the private sphere. You belong to home. You are a weaker sex, etc. So gender means a social construction of sex. Now, what the Supreme Court in its determination in the Gender Equality Bill said was that the bill was on gender, whereas the Constitution speaks of sex. But they are not totally separate. Sex and gender are 2 sides of the same coin. So, for example, as Gehan said, the Indian Supreme Court has recognized in 2014 a landmark judgment. We have taken up a non-discrimination clause and directly from the Indian Constitution. That also guarantees protection from sex discrimination. But the Supreme Court in 2014, this is Indian Supreme Court, recognized a third gender. That is the Hijra community, because there is a long cultural tradition, regarding the transgender community of India. So they came to court and said, look, we have our own identity. We have a specific gender identity, and we are being discriminated against, and we are being persecuted. While there's also recognition, like when a child is born, the Hijra community is brought in to bless the child and so on. But there's a major downside also, because they've been vilified and treated like second-class citizens. And the Supreme Court of India said, no, the right to life also means that, you know, your dignity means that your identity, your gender identity is absolutely important. That's important for you to live a dignified life and recognize the third gender. Now see, so sex is not, you know, totally different, distinguished from gender. So that is what we want, and I'm absolutely sure if the court really had the assistance of experts, the judgment may have gone in another direction, and I say this with deep respect to the court. I think this is the fault of all the parties, as Gehan pointed out. You know, when you try to steer a piece of legislation through that's complex, and that may have all these complexities and misunderstandings, it's really important to get those ideas, you know, the expertise, as he said, available into, you know, the process.
Gehan, any notes about the gender equality bill? Anything that comes to mind?
I mean,
contentions?
Okay, so I had some observations on the previous version of the bill. The Commission took up some observations and recommendations. The latest version that was finally placed on the order paper and challenged had some new provisions that I think could have led to difficulties, despite the fact that it wasn't really taken up in great detail by the Supreme Court. Now, the Supreme Court doesn't need to go into every single clause. Now, for example, it sets up gender focal points. And if you look at the definition of the institution that is required to set up a gender focal point, it includes virtually all institutions in the entire country. Right?
So it's cross-cutting.
Cross-cutting, private sector, public sector. Now, that might be a good thing, but you're looking at possibly tens of thousands of gender focal points. Then there is a reporting requirement, which includes a reporting requirement to the Parliamentary Caucus on Women. Now, imagine the Parliamentary Caucus on Women getting tens of thousands of these reports that it's supposed to process. So there's a slight lack of practical reality that has slipped into this. I don't think insidiously or maliciously, but by virtue of the fact that when a law goes through many iterations and it is done in a slightly closed manner, you don't give an opportunity for fresh eyes to actually spot these things. Right? And it's very important for that lawmaking process not to be insular, because humans make mistakes.
Sure.
And there's something valuable about actually having fresh eyes spotting things. I'll give you another quick example. Look at the Online Safety Act. Now, that was done in this rushed, chaotic manner. And then they even wanted to rush the process of having those committee stage amendments. So much so that the Human Rights Commission, when it compared the final act with what was required by that determination, we spotted something like 8 or 9 clauses that didn't have the required amendments, which actually creates a bit of a constitutional crisis. And now Supreme Court, there's a 5-member bench that will take this matter up in July, where they will have to consider whether this is law or not, whether the Speaker actually certified a piece of legislation or is it something else. Because you cannot actually pass this piece of legislation with a simple majority unless you rectify the problems that have been identified by court. Because what court does through a determination is not issue necessarily a judgment. It's prescribing the process through which this particular piece of legislation can be passed, either by a simple majority, by a special majority, that's a 2/3 majority, or a special majority plus referendum. Now, when the Supreme Court says that this particular bill cannot be law except by a 2/3 majority, what it's basically saying is, if you only get a simple majority, it's not law.
Exactly.
So we have a problem now. And I think you can just put this problem down to a lack of good faith and sincerity in ensuring that fresh eyes see this, and you pass a piece of legislation that is really in keeping with the Constitution.
Absolutely. Gehan, is there any way at all where the ethos of the bill can be resuscitated now
Yes,
that it
yes,
has
of
been
course. Of course.
struck down. How should that process work?
I don't think the champions of this bill should see this necessarily as a major defeat. I think the fact that we are taking this up, we're having this conversation, means that this is still a current issue, and sometimes when you fail, you have to just pick yourself up and try harder.
Right.
So I really value the legislative effort here, and we have to credit those behind this effort as trying to do something good. And I think it's also important to understand that a determination is not necessarily binding on the Supreme Court, because it's not a final judgment. It's a slightly different type of animal, if you can call it that. This determination is actually prescribing the process through which a particular bill needs to be passed. Now, that doesn't stop the court from considering a new bill, which might also be challenged. I think the intervenient petitioners need to learn a little lesson there, that they need to be in there fast and not wait for the last moment and try to, they took up a interesting argument that 14 days should start only at the point of the bill being read in Parliament. But, court took up the I think, correct view that it 14 days start when it's placed on the order paper.
Right.
Now, you shouldn't really take those chances, right? So I think court also was deprived of those views in support of the bill because we were not organized well enough. Right? The moment a bill is gazetted, that is the moment you start preparing, right? Because the order paper, being placed on the order paper, you only have 14 days. But even before that, it has to be gazetted, and they cannot place it on the order paper unless 14 days pass from the date of gazetting. So actually, you have about a month to start preparing your defense.
Sure.
So I think lots of lessons to be learned, and I don't think people should give up on the campaign to bring a gender equality law.
From that technical discussion, I'd like to move on to a more justice-based conversation, Dr. Udugama. Recently, I was scrolling through TikTok, and it's interesting that there was this conversation where this random person walks up to women and he asks them, would you rather be stuck with a man or a bear in a forest? And all the women think a while and they say, a bear, because the bear would just maul me and leave my body alone. And then this same guy also goes and asks men who have daughters, and all these men also say probably the bear. So how do we deal with this ubiquitous issue of misogyny, which we are not addressing in all the spheres, the political, when it comes to bodily autonomy, cultural liberation, religious freedom, safety and security, sexual pleasure? We're not talking about the misogyny.
Absolutely. It's simply because, again, it's like the legislative process. We are focusing on numbers but not the quality. So, for example, if you look at the achievements of women in Sri Lanka, their educational, health, indicators are very good, and so on. But, the societal dimensions of, the aggression against women, the perceptions of women, etc., are not being dealt with. So, if we start with the education system, that's where it all begins, where young minds are formed and attitudes are formed and so on. The education system hardly deals with these issues of gender, now for example, and also there's no sex education. Let's call it reproductive health education. For want of a better word, there has been this resistance. So where do human beings at various stages of our lives learn about the gender dimension, the gender dimensions of our lives? We don't get those opportunities. So even students who come to the university, they are considered to be the cleverest and they are very smart, but yet on these issues, they've never had an opportunity of understanding these issues in an in-depth manner or discussing these issues in an in-depth manner. And many graduate from the university without any exposure whatsoever. So that means in your whole life, you never get that opportunity. So there are women all everywhere in society, in schools, in tuition classes, in universities, in the workplace, etc. But yet there has been no enlightened conversations about this. So this is where this huge gap, is there. And so this is, I think, the fundamental reason why there is this degree of misogyny. There are other reasons as well, I'm sure, but I think the main point is that we don't quite understand, the other, so to speak. And sexuality, gender issues are very hard to talk about. This is part of life. The Hate Pota was formulated, this is on reproductive health, that the Ministry of Health formulated, and it was formulated by medical personnel who are into community health, and these were experts. As Gehan said, Sri Lanka is full of this expertise, and it's a beautifully crafted book for children from grade 7 upwards. That was that's my recollection. But then when it was about to be introduced and it was taken up by the sectoral committee in Parliament, there was this opposition, and that was from religious point of view, that was so rejected. So when do we have this opportunity of talking about these issues? So we always then say we want more laws. We want more laws to criminalize. We want more laws criminalizing sexual harassment and all that. Those laws are needed. But however many laws you bring, they cannot be properly implemented because we haven't got the correct attitudes and the correct value base to enforce them. Very briefly, 1995, the penal code was strengthened with regard to offences against women and children. But offences against women, the implementation remains at a very low level. How many years later now? How many decades later? Why is that? The officials who are in charge of enforcing those laws really, don't have that commitment or the understanding of what women go through. It's better, I think, with regard to children. There's empathy and understanding. So this is where I think the education system, more than anything else, really needs to focus on these dimensions.
Gehan, we're talking about, we have an obsession with retributive justice, right? Locking up the wrongdoer, locking up the rapist, the murderer, the wife beater. And then we have the detention centers for abused women. We have the centers for the young girls who get pregnant out of rape and incest, and then we put them in those centers. We have probation centers. So we are not addressing the abusers. There is a lack of psychosocial care. We're only focusing on victims after something bad has happened. I'd like you to focus on why we take away agency from women, why we're so obsessed with male control, and why we keep perpetuating this shame-based culture among women in Sri Lanka.
So, thanks for such an easy question. I think I'd like to, so it's a difficult question to answer. I want to just pick up on something that Professor Udugama said about religion, because religion goes so hand in hand with control. And I think you will see in many debates, not in all debates, but in many debates about women's issues, religion is often placed front and center as a justification for maintaining the status quo of control. And we see religion playing a part even with the gender equality bill, right? It plays a large part in the arguments of the petitioners with respect to why this shouldn't be done. And religion and culture also go hand in hand, and often culture really starts to spill over into religion. And actually, if you look at some of the theologies, what is being promoted is inconsistent with the theology, but it's the cultural interpretation of what the theology says that takes precedent. And I think we need to ask ourselves the question about the role of religion when it comes to matters of equality and discrimination. Because freedom of religion is an extremely important value, but it cannot be placed with in a tension with principles of equality and non-discrimination. And courts and treaty bodies around the world have dealt with this issue and have always found that freedom of religion has to be respected, restrictions can be introduced, but ultimately they cannot be discriminatory. Right? And a classic example was that, when it came to the headscarf issue, in many jurisdictions, these were being banned.
Or the talaq divorce.
The talaq divorce. Principle of non-discrimination is often a trump. And I think it's time that we take a very firm stance that communities do have their rights to religion and culture, but they cannot be non-discriminatory. And Professor Udugama made a really important point about children. We have made that leap when it comes to children. When it comes to children, we are very happy to say, no. A religion that treats their children badly, no. We have a right to intervene because the court is the upper guardian or best interests of the child. These are very important principles, but very loose when it comes to women. So I think when we talk about control, we have to also be critical about the instruments of control. And we are very nervous about critiquing religion, right? Because from a human rights perspective, at least, it's about freedom of religion or belief. But from a sort of cultural perspective, there's always this understanding that, religion is very sacred, we shouldn't be critiquing it, we shouldn't be overstepping the mark. I think it's important that we see these connections. And often discourses, ideologies, and I dare say even faiths are used as vehicles, as justifications for keeping communities in their place. And it could be caste, it could be ethnicity, and it certainly could be sex and gender.
All right, fantastic. What a beautiful conversation. Thank you so much, Professor Deepika Udugama and Dr. Gehan Goonetilleke. Thank you.
Most welcome.
Thank you very much.
Thank you for watching us. We'll see you again next Friday. Good night.